At exactly 10:03 a.m., the velvet-curtained courtroom of the U.S. Supreme Court fell silent. Sunlight streamed through tall windows, casting solemn shadows on the marble floor. Justice itself seemed to be holding its breath. Judge Evelyn Mercer, famed architect of the Online Hate Prevention Act, adjusted her glasses. With decades of legal influence behind her, she was now overseeing the law's final constitutional test. Across the courtroom sat Karoline Leavitt. No lawyer, no script, just a sheet of handwritten notes and the Constitution tucked in her jacket pocket. She had come not to speak, but to stand against what she called censorship disguised as compassion. The room was tense. Cameras rolled. Scholars, tech CEOs, and activists filled the gallery. Knowing this was more than a hearing, it was a defining moment for free speech in the digital age. Before we go deeper into what unfolded behind those solemn stone walls, subscribe to Hidden Stories, because sometimes the most powerful voices are the ones no one expects. Today's story will show you how one young woman's courage changed the course of American law forever. Karoline's story didn't begin in this courtroom. It began in her teenage bedroom in New Hampshire, watching tweets vanish and accounts disappear in 2020's wave of digital censorship. One moment hit hardest. Her friend Marcus, a quiet history lover, was banned from Twitter for quoting Jefferson, "The Tree of Liberty." The quote was flagged as violent. That night, Karoline couldn't sleep. She dove deep into free speech law, reading landmark cases like Schenck, Brandenburg, and New York Times versus Sullivan. By 19, she was auditing law classes at Dartmouth. At 20, writing amicus briefs. By 21, she had become a leading voice in digital rights. Her blog, Digital Dissent, drew tens of thousands. Her YouTube channel reached millions. But she wasn't just an influencer, she was a legal mind, spending long days in libraries, tracing how speech evolved from parchment to platform. Karoline's opponent was no ordinary jurist. Judge Evelyn Mercer was a titan. A former Yale professor and Rhodes Scholar, Mercer had shaped American speech law for decades. Her resume? Supreme Court clerk to Justice Scalia, 47 cases argued before the court, 43 victories. But behind her formidable intellect lay a personal wound. In 2018, her daughter was targeted in a brutal online harassment campaign. Death threats, relocation, silence. That experience shifted Mercer from free speech absolutist to advocate for digital safeguards. Her answer? The Online Hate Prevention Act, a sweeping law granting the government broad power over speech labeled socially destabilizing. Critics called it censorship. Mercer called it necessary evolution. At the heart of the case was a controversial proposal. A federal digital safety board empowered to label content as harmful discourse, with criminal penalties up to 3 years in prison. Staffed by unelected officials and tech executives, the board would operate with little oversight. Civil rights groups were divided. 23 supported it, 17 opposed. The nation was split. And everyone knew this Supreme Court session would define the future of speech in the digital age. Judge Mercer's gavel struck sharp, final. The chamber fell still. Every eye turned to Karoline. "Miss Leavitt," Mercer said, voice precise and firm, "you claim the Online Hate Prevention Act violates the First Amendment. Tell me, do you believe hate should be protected?" The question cracked through the courtroom like thunder. Reporters leaned in. The trap was set. Karoline felt the pressure, every heartbeat loud in her ears, hands trembling. This wasn't just a personal stand. It was a moment that could shape the future of free speech in America. It was a strategic trap. By framing the debate around hate, Judge Mercer had forced Karoline onto dangerous ground. Defend too strongly, and she'd seem to protect the indefensible. Concede even slightly, and her entire argument would collapse. In the press box, a CNN analyst whispered, "Checkmate. How does she dodge this without sounding like she's defending Nazis?" Silence. 1 second. 2. 3. Karoline's mind raced. Marcus's ban. Algorithmic silencing. A future where the government defined acceptable thought. The stakes had never felt more personal. Then she remembered why she was here. Not to win political points or score rhetorical victories, but to defend the principle that had made America possible. The idea that truth emerges from the clash of ideas, not from the silence of dissent. She looked Judge Mercer directly in the eye. Karoline didn't flinch. Her voice was calm, clear, unwavering. "Definitions matter, Your Honor. And no government, no matter how noble, should decide what counts as hate. That's not protection. That's control. A ripple passed through the gallery. Even legal scholars nodded. Mercer hadn't expected this. She pressed further. So if someone calls for violence against a minority? Karoline raised her hand gently. We already have laws for that. Brandenburg versus Ohio set the standard: speech must incite imminent violence to be criminal. This bill abandons that. It punishes tone, not threat, discomfort, not danger. The battle had begun. Judge Mercer launched into her argument, citing DOJ data showing a 400% rise in hate crimes linked to online radicalization, FBI reports on domestic terror recruitment, and studies on the psychological toll of online harassment. Ms. Leavitt, she said sharply, should victims like journalist Sarah Chen or Dr. Marcus Williams have no protection? 50,000 death threats. Doxing. Should we do nothing? Karoline nodded solemnly. Their pain is real, but giving the government power to define dangerous speech is a greater threat. Under this law, even Dr. Williams could be silenced if his research made the wrong people uncomfortable. Karoline shifted gears, now building her case on firm constitutional ground. She quoted Justice Brandeis, "The remedy to be applied is more speech, not enforced silence." Then New York Times V.W. Sullivan, "Public debate must be uninhibited, robust, and wide open, even when it's unpleasant." The framers understood, she said, voice rising, that bad ideas are defeated by better ones, not by government censors. The moment we let bureaucrats decide which opinions are allowed, we stop being a free society. Judge Mercer changed course. This isn't a speech law, Ms. Leavitt. It's a safety protocol, guided by objective metrics. Karoline calmly opened her folder. Then why does Section 4 let unelected tech task forces pre-flag user content? Why does 4.2 allow retroactive censorship? Gasps rippled through the courtroom. She continued. And Section 7, emotional destabilization as grounds for removal? That's not law, it's a feeling. Who decides which emotions are acceptable? Judge Mercer's composure began to crack. This was dangerous territory language she herself had crafted in earlier drafts, language she thought had been refined out of the final version. Furthermore, Karoline pressed, Section 12 establishes community standards that can override constitutional protections if content is deemed socially disruptive. But, Your Honor, the Boston Tea Party was socially disruptive. The Underground Railroad was socially disruptive. The Civil Rights Movement was socially disruptive. Under this law, Frederick Douglass could be prosecuted for his speeches against slavery. The comparison hung in the air like smoke from a cannon blast. Are you suggesting, Judge Mercer said slowly, her voice tight with controlled anger, that this law is unconstitutional? Karoline met her gaze without flinching. I'm suggesting it's un-American, Your Honor, because once we silence offensive speech, we lose the ability to distinguish it from truthful dissent. Once we trust the government to protect us from bad ideas, we've already surrendered the freedom to think for ourselves. In the back row, a Georgetown law professor muttered to his colleague, "She's channeling John Stuart Mill, and she's doing it perfectly." Then Karoline produced her bombshell, a thick folder marked with official government seals. Your Honor, I submit into evidence the Government Oversight Committee's sealed report on federal social media coordination, released under FOIA request 2024-7731. Judge Mercer's eyes widened. That report was classified until declassified last Tuesday, Karoline interrupted smoothly. The American people have a right to know how their government has been shaping their speech behind closed doors. Karoline opened the folder and began reading. These documents show that multiple social media companies received behavioral flagging suggestions from 17 different federal agencies months before this bill was even introduced. Page 47 shows the Department of Homeland Security's guidelines for identifying potentially dangerous discourse. Page 73 shows the FBI's recommendations for algorithmic suppression of anti-government sentiment. The courtroom erupted in murmurs. Reporters frantically scribbled notes. Camera operators zoomed in on Karoline's face. But here's what's most troubling, Your Honor, Karoline continued, her voice rising slightly. Page 92 includes your name, Judge Mercer. You personally advised on draft wording for what would become the Online Hate Prevention Act. You helped craft the very definitions of harmful speech that your court is now being asked to uphold. The revelation hit the courtroom like a lightning strike. Judge Mercer stiffened. For the first time in her storied career, she wasn't just presiding, she was implicated. "This bill doesn't protect citizens," Karoline said, her voice calm but cutting. "It protects power. It shields institutions from criticism, silences dissent, and insulates the elite from accountability." She let the silence settle. "And that, Your Honor, is the tool of dictators, not democracies." Judge Mercer leaned back, shaken. For the first time, the power in the room had shifted. Karoline hadn't just challenged a law, she was putting the entire constitutional process on trial. The gallery stirred. Scholars texted feverishly. Journalists rewrote headlines. C-SPAN lines lit up. Outside, the plaza had become a movement. Jumbotrons streamed the hearing live. Food trucks lined the streets. Chalk art of the First Amendment covered the sidewalks. Protest signs rose. "Let Karoline speak. Defend digital democracy." The internet erupted. Within an hour, Leavitt Speaks passed 1 million mentions. Her courtroom clips went viral. On TikTok, young Americans posted about the Constitution, many for the first time. Her phrase, "I believe definitions matter," became a movement printed on shirts, mugs, and protest signs across the country. Perhaps most remarkably, Karoline's arguments began uniting people across political divides. Progressive activists who had initially supported the Hate Prevention Act began questioning whether they wanted the current government or any government to have such broad censorship powers. Conservative commentators who had dismissed Karoline as a liberal troublemaker found themselves applauding her defense of constitutional principles. The ACLU, which had been internally divided on the law, issued a statement. "Ms. Leavitt has reminded us that civil liberties cannot be sacrificed for temporary safety, no matter how well-intentioned the sacrifice." Karoline did the unthinkable. She built a bridge across the political divide. Progressives who once backed the Hate Prevention Act began to reconsider the risks of government overreach. Conservatives who had dismissed her now praised her unwavering defense of free speech. Even the ACLU, once split on the issue, released a statement. "Ms. Leavitt reminds us, civil liberties must never be traded for temporary safety, no matter how noble the intent." When the court resumed at 2 p.m., something had shifted. Judge Mercer looked weary, less certain, more human. "Ms. Leavitt," she asked softly, "what would you have us do? How do we protect the vulnerable and still honor the Constitution?" It wasn't a challenge. It was a plea. Karoline answered with quiet strength. "We trust Americans, Your Honor, to hear bad ideas and reject them, to debate, to argue, to grow. That's what citizens do, not subjects." Coverage was swift and unanimous in its awe. Fox News called it a masterclass in constitutional advocacy. MSNBC admitted it was a necessary confrontation with government limits. And NPR concluded, "Karoline Leavitt made the nation rethink who holds the power to define the law. Her words will echo in law schools for generations." The world was watching and responded quickly. The EU paused its own digital safety legislation, citing the need for further constitutional analysis. The UN Special Rapporteur on Freedom of Expression declared, "The Leavitt hearing highlights the global struggle between safety and liberty. Her arguments merit serious reflection by all democracies." 3 weeks later, the Supreme Court struck down the Online Hate Prevention Act in a 5-4 ruling. Justice Gorsuch, writing for the majority, declared, "Free societies cannot be built on silent fear. Defining harmful speech is the first step to silencing dissent." Ms. Leavitt reminded us, the answer to bad speech is more speech, not enforced silence. Even Justice Sotomayor, dissenting, admitted. Ms. Leavitt's arguments challenged us all to reconsider the limits of government power. The ruling hit Judge Mercer hard. Days later, she announced her resignation. "I believed I was defending truth," she wrote, "but Ms. Leavitt reminded me truth must stand on its own. The Constitution protects not just the speech we cherish, but the speech we fear. And freedom demands vigilance not just against enemies, but against ourselves." After her victory, the offers poured in: book deals, TV spots, political endorsements, even whispers of a presidential run. She declined them all. Karoline quietly returned to New Hampshire. No speaking tour, no headlines. At the airport, when asked why, she simply said, "I didn't defend the Constitution to become famous. I did it because it needed defending." Back in her cozy apartment above a Portsmouth bookstore, Karoline returned to what mattered most: reading, writing, teaching. Karoline addressed the UN's Global Forum on Digital Rights virtually, From her bookstore desk, her 20-minute talk became the most watched UN speech ever. 12 countries began reviewing their speech laws. Across 5 continents, the Freedom Filter movement took root, pushing back against government control over online expression. Karoline's impact reached the very heart of legal education. Harvard launched the Leavitt Fellowship for students defending constitutional freedoms. Yale created a digital democracy initiative inspired by her arguments. Even the ACLU and Federalist Society co-hosted a symposium in her name. Her Supreme Court brief became required reading in law schools worldwide. Professors taught it, students debated it, and mock trials began modeling Leavitt-style defenses of free speech. Most touching recognition, came in a handwritten letter from Marcus, her old friend banned for quoting Jefferson. "You fought for my voice when I couldn't. You proved one person can still make a difference." Karoline pinned it above her desk, beside a worn copy of the Constitution and a photo of her parents. Historians now speak of the Leavitt hearing in the same breath as Gideon v. Wainwright or Brown v. Board, not for its precedent, but for the principles it reignited. Professor Lawrence Tribe wrote, "The Constitution is not a museum piece. It lives or dies by our choices." Karoline Leavitt chose honor and reminded us all to do the same. 2 years on, Karoline still lives quietly in New Hampshire, writing, teaching, and defending the Constitution in small, steady ways. She's declined fame again and again, choosing impact over spotlight. When asked why, her answer never changes. The Constitution doesn't need celebrities, it needs citizens. This wasn't just a legal battle, it was a national reckoning when America remembered that freedom begins with letting all voices speak. And it all started with one quiet sentence from a young woman who dared to challenge silence. "I believe definitions matter, Your Honor." 4 words that echoed through history and helped save American democracy. Who do you trust to define hate? Who decides which ideas are too dangerous for you to hear? And when they silence speech you despise, who will defend the speech you believe in? Subscribe to Hidden Stories. Because freedom's most crucial battles are often fought by the least likely heroes in the quietest corners of history. And sometimes they win.